మొబైల్ నంబర్ చెప్పు పాప. 27 3 1 3 1 2 9 8 0 1. మీ భార్యదే ఒకటేనమ్మా. సిగ్నేచర్ చేస్తావా? సిగ్నేచర్ చేసేకొచ్చా? సంతకం చేస్తావు కదా? అదేంటి ఆಗಿದೆ 18 ఏళ్ళు అయిందా కొడుక్కి? డేట్ ఎంత? డేట్ ఏమ్మా? డేట్ ఆఫ్ బర్త్ ఏమ్మా? అది కాదు, అది కాదులేండి, వేరే. డేట్ ఆఫ్ బర్త్ కావాలి నాకు. కనుక్కో కనుక్కో చెప్పారు కదా నాకు ముందుగానే ఇట్లా అయింది. వాడిని అయితే వాడినే రమ్మంటాం, వీళ్ళు వాడిని రమ్మంటాం. కాదమ్మా, అట్లా కాదు, ఇప్పుడు వచ్చిండారు కదా, ఆ రెండు చేసగా ఉండే ఇప్పుడు మళ్ళీ పోయి మళ్ళీ వాడిని పిలుచుకొని మళ్ళీ వచ్చి ఎన్మాట పారాడతారు ఏం చదువుతా ఉన్నాడు ఇప్పుడు పదో క్లాస్ మార్క్స్ కార్డు ఉందా ఉమ్, చూపిస్తా.
Take notice. Okay. ಇವತ್ತು ಯಾವ್ದು ಇಲ್ಲ ಆದ್ರೂ ಬನ್ನಿ ಒಂದು ಅಟೆಂಡೆನ್ಸ್ ಮಾಡಿ.
ಸರಿ ಇನಿಷಿಯಲ್ ಎಸ್ಎನ್
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಕಾಣ್ತಾ ಇಲ್ಲ, ಕೋರ್ಟ್ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಹಾ ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಇದ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಸರಿ ಸರಿ, ಓಕೆ 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 ಥ್ಯಾಂಕ್ ಯು.
Hardship may kindly have
Permission.
tomorrow, my lord, I am withdrawing the appeal. Tomorrow,
Why tomorrow?
because they have settled the matter before the court.
Lord,
Yes.
with my lord's permission for tomorrow, I filed an application for extension for deposit of the. My lord, the interim order was dated 12/2/2024, wherein 50% had. to be deposited. Giving an application for
Should be
extension,
deposited within
4 weeks. from
when the order was given,
12/2/2024.
12/2/2024.
My lord.
Then how
An
can,
application for extension, my lord, only for this reason.
let it come in its own course? No,
Execution
the
is being
council-
filed, my lord.
at least after that 4 weeks, you would have filed an application, we would have after the 5 months of period, now we
My
are
lord,
moving.
but, Lord,
No, we
case
cannot
had
entertain.
different matter, my lord.
Let it come in the regular course. Yes,
Ease of amendment.
yes,
Insurer appeal stay
take the matter.
tomorrow for.
What is the urgency, Mr. Council?
Agency means they might execute the award and.
Let it come in the, take,
I have filed an appeal for release of amendment.
take. Yes.
Means page wise from admission. Page 7, 31 to 33.
My lord,
Page 8, 34 to 38. Page 9, 39 to 44. Page 10, 45 to 47.
45, yes.
I'm for the.
Huh?
Company challenging liability.
PCR is required.
You have not filed wakalat for respondent number 1 in the connected matter. Yes. Sri Satisha T. When counsel on record for the appellant in MFA 7181 of 2022 seeks time to file wakalat for respondent number 1 in the connected appeal, that is MFA 6511 of 2022. Next, third, admit both the appeals. For the records from the consent tribunal. List both the matters under the caption final hearing on 13th November.
Page 10.
Serial number 47, my lord.
Yes, 47.
Paper a short accommodation. My colleague went to his native due to the ill health of his mother.
See, Ashok and Patil has not filed wakalat for respondent number 2. Let us see the there
40.
47 in
47.
have not filed wakalat, Mr.
Kalat not filed. 47 is filed. I have filed.
Land Council Sri Ashok and Patil submits that he filed wakalat for respondent number 2. What is to verify and to put up. Next, you are Mr. Nanjagowda.
Please, ma'am.
Hard Sri Nanjagowda TV Land Council for the appellants. Admit. List the matter under the caption final hearing on 29th October. 29th October.
Page 11, 48 to 52.
Serial number 50, my lord.
50. Yes.
50, I am for the appellant, my lord. But in this case, my lord, kindly refer to Lok Adalat, my lord. Claimant.
At request of
KV.
KV Nayak, Land Counsel for the appellant, the matter is referred to Lok Adalat for settlement.
Serial number 48. I appeal for respond number 1. But in this case, not I have been informed that yesterday, Wakalat was dispatched. Some will exhibit. I request for a short accommodation in this case.
Sri Ashok in
Shastri.
Yes, inform me.
to file
Yeah.
Wakalat for respondent number 1. Time as prayed for is granted. Stand over to 15th October.
Serial number 52, my lordship. TCR is maybe requirement in this case. For the appellant,
No representation for respondents, none appears.
notice served, my lordship.
One served and represented.
Yes, heard Sri Janardhan Reddy, Land Counsel for the appellant. Admit, call for the records from the consent tribunal. List the matter under the caption final hearing on 5th November.
Serial number 65, my lord.
Serial number,
Page 12. 53 to 58.
my lord, serial number 54, my lord, 54.
Yes,
My lord, another connected matter, 6944/23. Maybe post.
Land Counsel Sri for appellants appears through VC and submits that MFA
6944/23.
is connected to the present appeal. Full stop. Seeks to list both the matters on the same day. Full stop. Hence, register to verify and to list the present appeal along with the MFA so and so on 15th October.
56, my lordship.
Serial number,
Wakalat, 1 week time will be granted. Wakalat are not filed in this case.
Let us see the record, Mr.
My lord, 33 and 35, refer to Lok Adalat.
Serial number 61, my lord, admission matter.
Lordship, serial number 57, Lordship.
57,
Yes, my lordship. In this case, my lord, the Land Counsel for the respondent number 2, my lord, B. Pradeep, grandmother died. He requested me to take adjournment. He is not ready. 57, my lord.
Mr. Srinivasan MY,
Yes, my lord. Yes, my lord.
Sri Srinivasan MY for appellant submits that. Let us see, Mr. Counsel, Wakalat is not filed, let us see. Let us. see.
He is not in station. That's why, my lord.
Let us see, Mr. Counsel, let us.
Please.
see. We'll judge.
Page 13. 59 to 62.
60, page, serial number 60, my lord.
60, yes.
The same thing, my lord. I have sent the papers to Madras on Friday. He served the copies. I have not received because
Sri H.S. Lingaraj and counsel seeks time to file Wakalat for respondent number 2. Full stop. Time for 2 weeks is granted. List on 22nd October.
much.
Serial number 61, my lord. For respondent in this two matters.
I am for appellant, please.
Short accommodation maybe.
Why, Mr. Counsel?
Please, my lord, the Wakalat has not been shown, even though I have filed Wakalat for R1. So it has been shown as a not filed on 20.
Let us see when the matter is called. Yes.
Hello, short accommodation,
Short.
please. And I'm not fully prepared in this case, that's.
Sri Ravish Benny Chandrasekhar, learned counsel for the appellant in both the matters, as well as Sri Anandeshwar T.R.
Please.
learned counsel for respondent number 1 in both the matters, seeks time. Hence, list both the matters on 26th November.
My lord, serial number 67, my lord.
67.
1 minute, Mr. Counsel. Next.
Page 14, 63 to 66. Page 15, 67 to 70.
My lord, in the serial number 67, my lord, recently I
Serial number
received a copy of the appeal memo and sent it to KSRTC. They are processing it, my lord. They may send the papers.
Let us see, Mr. Counsel, after verifying the record.
Please, my lord.
Serial number 65, my lord.
33, 35.
When the matter is called, you can represent, Amma. Yes.
Serial number 65, my lord.
Serial number
65.
65, yes.
A week's time may be granted, my lord. I already informed the other side also.
This is 2022 matter, Mr. Counsel.
Please, my
Lord, I
lord.
appear for the second respondent.
A week's time may be granted, my lord. Not feeling well,
Sri Harish Babu KN, Land counsel for the appellants appears through VC and seeks time. The appeal is of the year 2022. Full stop. However, to accommodate time as prefer is granted. List on 19th September.
In the meantime, LCR may be call for my love.
For orders, serial number 1, Jwala Kumar.
Await service of notice. Who is respondent number 2?
Point number 2, notice dispatched.
Await service of notice upon respondent number 2.
Serial number,
List on 22nd October.
serial number 2, R. Shashidhara. Case Sridhar for R2.
Respondent number 2, my lord. Appear for a appellant, my lord.
Yes.
We take steps to 2 weeks, my lord, because of R1 address, collected the address.
I am for.
Yes, my lord.
Your good name.
Good name, Geetanjali.
Huh?
Geetanjali.
Miss Geetanjali representing Sri R. Shashidhara, Land Counsel for the appellant, seeks time to furnish the requisites. Full stop. Time for a week is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 1. List on 12th November. List on 29th October.
Serial number 3, Jagadish HT.
Srimati Manjula and Tejasvi is called upon to accept notice for respondent number 2 and file wakalat subject to the entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Srimati Manjula and Tejasvi. Await service of notice upon respondent number 1. List on 22nd October.
Serial number 4, Geeta R. BP Radha.
I am for the appellants.
Await service of notice upon respondent number 1. List on 29th October.
Serial number 5, Ravi S. Samprati.
Appellant. Lord, I paid the process to respond number 1 on 7th of August. I'll verify I'll pay the appropriate process fee.
Insufficient address.
I'll file an necessary application by paper publication for R1.
To send for another time. Land counsel.
Third time.
Have you deposited? the
Yes, my lord.
amount
I have
on-
produced the receipt also along with the appeal. The sum of rupees 4,54,794 was deposited. And it was being produced along with the appeal.
Sri Ravi S. Samprati seeks time to furnish the requisites. Time for a week is granted. Full stop. On furnishing the requisites, office to send notice to respondent number 1. Full stop. Sri Ravi S. Samprati submits that proof of having deposited the award amount was filed. Full stop. Office to verify and to office to verify. List on 5th November.
Public.
Serial number 6, NR Rangegowda. P. Shankar Reddy.
Memo for dispensation of notice to R1.
Memo seeking dispensation of notice upon respondent number 1 is on record. Why it should be dispensed with? Mr.
Lord,
Counsel?
liability pitched against the insurance company.
Land Counsel Sri Rangegowda NR submits that as liability is fixed against respondent number 2, comma notice to respondent number 1 may be dispensed with. Having considered the submission thus made, comma notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
Refer to Adalat.
At request, the matter is referred to Lok Adalat for settlement.
Bill number 7, P. Mahadev Swami, Janardhan Reddy.
Lord, in the connected appeal, the company, insurance company has also filed an appeal. In that, Manjula Tejasvi is.
Your Lordship, I am appearing for the appellant in this case.
Janardhan Reddy's name may kindly be deleted.
Yes.
Lord, I am taking steps today, respondent number 3, madam.
Your Lordship, I am taking steps, I mean, giving one IA copy to the section, Your Lordship, for issuing notice to respondent number 4.
The P. Mahadeva Swami for appellant submits that the requisites would be furnished during the course of the day. Full stop. On furnishing the requisites, office to send notice to respondent number 3 in MFA 1379 of 2022. Full stop. It is reported that in the connected matter, as it is reported that in the connected matter, Srimati Manjula and Tejasvi is appearing for the insurance company. Hence, Srimati Manjula and Tejasvi is called upon to accept notice and file wakalat for respondent number 5 in MFA 1379 of 2022, subject to entrustment of the case otherwise by respondent number 5. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Srimati Manjula and Tejasvi. Next paragraph.
Applies to Your Lordship.
Next paragraph. So far as MFA 1171 of 2021 is concerned, Srimati Manjula and Tejasvi, Land Counsel for the appellant, appears through VC and seeks time to comply the office objections. Full stop. Time for 2 days is granted. Full stop. On
Applies.
complying the office objection, office to send notice to respondent number 4. List on 5th November.
That Janardhan Reddy's name may kindly be ordered to be deleted. In the second appeal,
It has not filed with that.
please.
Please. Office is directed not to show the name of Sri Janardhan Reddy for R5 in MFA 1379 of 2022.
Serial number 8, Sripad V. Shastri.
My lord, I am for appellant, my lord. I filed a memo for dispensation of notice to R1 because insurance company held liable and liability is totally foisted on the insurance company.
Court office में count तो कम करना है. Memo seeking dispensation of notice upon respondent number 1 is on record. Sri Sripad V. Shastri, Land Counsel for the appellant, appears through VC and submits that as liability is fixed upon respondent number 2, notice to respondent number 1 may be dispensed with.
My lord, this matter may be called along with 3424/22.
Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next paragraph. Sri Sripad V. Shastri submits that the present appeal is connected to
3424/22.
22. Seeks to list both the matters on the same day. In the light of the submission thus made, office to verify and to list the present appeal along with the MFA so-and-so on 22nd October.
Serial number 9, Satisha T.
Appearing to the
Ashok N.
second
Patil.
respondent in this case, Your Lordship.
Why both names are so shown, Ashok and Patil, Manjula and Tejas?
I have filed wakalat on 12/9/2022, Your Lordship.
My name may be Malad, sir, deleted.
Deleted. Ashok N. Patil.
Memo seeking dispensation of notice upon respondent number 1 is on record. It's heard Sri Satisha T. Land counsel for the appellant. Why it should be dispensed with, Mr. Counsel?
Liability fixing insurance company.
And counsel submits that as liability is fixed upon respondent number 2, a notice to respondent number 1 may be dispensed with. Fixed up. Having considered the submission thus made, a notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next. Land counsel Sri Ashok and Patil submits that as Srimati Manjula and Tejasvi is on record, representing respondent number 2, his name may be deleted. Full stop. In the light of the submission thus made, office is directed not to show the name of Sri Ashok and Patil in the cast list hereafter. Stop. Next. Admit, call for the records from the consent tribunal, list the matter and the caption final hearing on 29th October.
Serial number 10, Satisha T.
Employment appeal for an answer.
Ashok N. Patil.
Appeal for the second respondent in this case.
Shrikant.
We filed a wakalat on 8/9/22
L. Srikanta
for
Rao.
Shrikant Rao.
Yes, Mr. Patil.
Notes, I have also filed notes. He has filed prior to my wakalat notes. That his name may be shown.
Heard. Memo seeking dispensation of notice upon respondent number 1 is on record.
Yes, ma'am.
Why?
Liability fixing insurance company, ma'am.
Land counsel Sri Satisha T. submits that as liability is fixed upon respondent number 2, a notice to respondent number 1 may be dispensed with. It's not having considered the submission thus made, a notice to respondent number 1 stands dispensed with, however, at the risk of the appellant. Next point. Sri Ashok and Patil submits that as Sri L. Srikanta Rao has filed wakalat for respondent number 2, his name detailed. Stop. In the light of his said submission, office is directed not to show the name of Sri Ashok and Patil in the cast list hereafter. Stop. Admit, call for the records from the consent tribunal, list the matter and the caption final hearing on 29th October.
Serial number 11, Sripad V. Shastri.
My lord, I am for the respondent, my lord.
I am for appellant, my lord. Notice is await, my lord. Service of notice.
Await service of notice upon respondent number 1. List on 22nd October.
Serial number 12. 22nd October.
I appear for the appellant in this case, my lord.
Shank Rao.
I appear for the appellant. A week's time may be granted to take steps.
Who is representing?
I appear for the appellant, my lord.
Your good name, Mr. Counsel?
Shashank Rao.
You are not visible, Mr. Counsel.
L.
The
Srikanta.
video camera is on, my lord.
Shashank Rao.
He is a son of L. Srikant Rao.
L. Srikanta Rao.
Sri
Take your
Seshan
submission properly, Mr.
appears through VC and seeks time to furnish the requisites. Instead of time for a week is granted. On furnishing the requisites, office to send notice to respondent number 2. List on 5th November.
Publish.
Serial number 13,
13, my lord, I filed.
Vishwanath
My
Pujari.
lord, I am for the respondent, my lord. It can be disposed of.
No. I filed memo for withdrawal the appeal, my lord.
Withdrawal appeal.
Serial number 13.
Oh, idella, sorry. 13.
Memo seeking permission to withdraw the appeal is on record. Full stop. Heard, Sri Vishwanath Pujari K, Land Counsel for the appellant. Why you want to withdraw the appeal?
Because he has advised me to withdraw because he is not able to deposit the amount. Therefore,
Land Counsel, Sri Vishwanath Pujari K submits that the appellant is not interested to proceed with the appeal, and therefore he filed memo seeking permission to withdraw the appeals. In the light of the submission thus made, the memo is accepted and permission as prayed for is accorded. Next, the appeal is dismissed as withdrawn.
Serial number 14, Vishwanath Pujari.
in these three appeals may arise out of single accident. That all respondents in these three appeals are common appellant. I filed memo for dispensation of notice on R1 and 3. R1 is the owner of the offending vehicle.
Oh, is not on record, Mr.
I am fine.
My lord, I am on record, my lord. My name is.
Yes, yes,
My lord, in all the three appeals, I have filed wakalat
yes, yes,
on behalf of HDFC Ergo General Insurance Company.
yes.
I am filing memo dispensation R1 and 3, my lord.
It can be disposed of, my lord.
R1 is the owner of the offending vehicle, no liability.
Vishwanath Pujari K files memo seeking dispensation of notice upon respondents 1 and 3 in MFA 1536 of 2024. Learned Counsel submits that as respondent number 2 admitted his liability, notice to respondents 1 and 3 may be dispensed with. Having considered the submission thus made, notice to respondents 1 and 3 is dispensed with, however, at the risk of the appellant. Next page.
My lord,
In the next matter,
Next matter also, my lord, that is some
82 of 2000.
office note, my lord. That is a signature does not tally with the affidavit and wakalat. That the same Sharada has filed wakalat, signature in wakalat and affidavit.
they are all family members, my lord.
Acceptance of file by advocate Dr. Singh's notice yet to be answered. Counsel submission is regard to office. Whose signature does not tally?
That's the appellant Sharada. Is it does not tally with the wakalat and she put a signature in affidavit in IA for condonation of delay. My submission, my lord, she alone put her signature in wakalat and affidavit.
No, Mr. Counsel, this signature cannot be accepted. There are overwritings. File a fresh wakalat and also the fresh.
In other,
Sri Vishwanath Pujari K seeks time to file fresh wakalat as well as the fresh affidavit of the appellant.
in this case, in this appeal also, I filed memo for dispensation of R1 and 3, my lords.
Time for a week
common.
is granted. Next pair. Wakalat filed by Sri D. Vijay Kumar, Land Counsel for R2 is accepted. Next.
For R4, my lord, in connected appeal, R4 is directed Pradeep to take.
No, Vijay Kumar, I have filed. Oh, yeah,
That
is
is
the
your-
R4.
Vijay Kumar is for 2, for R4.
There is no liability, my lord, on that R4.
Mr. Counsel. Yes.
R4, there is no liability.
You file the wakalat, Mr. Counsel. Thereafter, we'll see with this.
Please,
bill. Next matter.
Can it be disposed of, my lord?
Third matter,
No, they have to file wakalat, Mr. Council.
14,412.
Yes.
Also, I filed memo for dispensation of R1 and 3.
14.2.
Sri Vishwanath Pujari K for appellant files memo in MFA 1431 of 2024 seeking dispensation of notice upon respondents 1 and 3. Full stop. And council states that as respondent number 2 admitted its liability, a notice to respondents 1 and 3 may be dispensed with. Full stop. Having considered the submission thus made, a notice to respondents 1 and 3 is dispensed with, however, at the risk of the appellant. Sri B. Pradeep Kumar has not filed wakalat for respondent.
Not filed. So far, not.
There's no liability also, my lord. Even liability is not in challenge. R2 HDFC Ergo Insurance Company is liable to pay. They have not challenged the negligence also on liability.
Sri B. Pradeep is called upon to accept notice for respondent number 4 in MFA 1431 of 2024 and file wakalat subject to entrustment of the case otherwise by respondent number 4. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri B. Pradeep. List all the 3 matters on 29th October.
Much obliged.
Please.
Serial number 15, Uttur Padmavati.
For respondent in this case. Number 1 KVA my lord.
SB Halli.
I filed a memo for withdrawal of the amount deposited by the appellant, my lord.
Have you deposited
Yes,
the amount?
we have deposited.
Any objection for recording?
No,
from-
minutes. 50% minutes amount may be minutes permitted to be withdrawn.
What 50%?
Minutes, we have deposited 50%.
Deposited 50%.
50%. Right? The amount may be minutes permitted to be withdrawn.
You have filed memo for withdrawal.
Please.
Memo for withdrawal of the amount, my lord.
You have to file an application, not memo. We cannot pass orders on memo. File an application.
May I make one submission on that? Still for the appellant has admitted to withdraw the amount more that. So you'll also make only accept the memo more that.
That will become a bad precedent, Mr. Council. We will list the matter on coming Tuesday. File an application in the meantime.
Please, ma'am.
At request of Land Council for your Mr.
KVA
Shankar-
respondent.
Oh, please, SB Halli, ma'am.
At request of
ನಮ್ಮ
Sri
quota number
SP
5
Halli,
ಅಲ್ಲಿ
Land Council for respondent
number
number 1.
ಎಂಟ.
List on 17th September.
Please, ma'am.
Serial number 16, Ashok N. Patil.
Minutes, I appeal for the appellant in this case. But this is an easy appeal, my lords. The office has raised an objection, my lords, non-compliance with regard to interest part, my lords, from 28 to 24 to 30th of August 2024 at 12% to be deposited. My lords, now we have deposited the amount, my lords, as per the order of the my lords, tribunal commissioner. The sum of rupees, my lords, 8,26,216 and also, my lords, 24,334. But my submission is this, my lords, the amount, my lords, is deposited in as per the award. The interest part, my lords, may not be, my lords, because we are challenging, my lords, under section 30 subclause 1A, my lords. That is, my lords, an order awarding as compensation a lump sum, whether by way of redemption of a half monthly payment or otherwise, or disallowing a claim in full or in part for a lump sum. You know, the proviso is provided that no further appeal by provided further no appeal shall lie in any case in which the parties have, I'm sorry, Minister. Provided further that no appeal by an employer under clause A shall be unless the memorandum of appeal is accompanied by a certificate by the commissioner to the effect that the appellant has deposited within the amount payable under the order appealed against. Therefore, the interest may not be necessary to be paid minutes at this moment.
Heard Sri Ashok and Patil. Land counsel for the appellant with regard to the office objection raised, full stop. The office objection regarding payment of interest is kept in abeyance for the present. Full stop. Issue notice to respondents on furnishing the requisites.
But I have sought for stay minutes, otherwise what will happen is that the amount will be dispersed. Therefore, minutes I have sought for stay minutes in this case. ECA minutes, we have to deposit the amount and then minutes file an appeal. Therefore, minutes may request for a stay of this minutes award.
IA 2 of 2024. No, Mr. Counsel, notice has to go. The delay is 2,549 days.
Yes.
How can we stay? Issue notice. to
Emergent notice may be issued. Madam.
Respondents on furnishing the requisites in the appeal as well as in IA 1 of 2024 and 2 of 2024. List on 5th November.
May I submit this minutes? In addition to minutes taking process, Lordship may kindly permit to take minutes notice on the advocate who appeared before.
Let the notice be served thereafter
Please.
if it is not
Please.
served. Please. Next.
Serial number 17, Anwar Ali,
In this case, appear for the appellant, my lord.
SN Mallan Gowda.
Copy for respondent number 1.
So, my lord, we filed a wakalat in the 487 of 2024 connected matter. Kindly post it for the matter for final hearing, my lord.
Let's say 487 fine. Mr. Court Officer, take the connected matter. 487.
Appear for appellant for 487.
Appear for the appellant for the 7602, my lord. I am the appellant, my lord.
Yes, Mr. Counsel, what about the office objection raised? What about the office objection raised in MFA 487 of 2024?
Swami, colleague Swami na. Pass over mali, kindly pass over. Sir, but.
My lord.
In the light of the office objection raised in MFA 487 of 2024, appellant is directed to file certified copy of the impugned order. List both the matters on 22nd October.
Serial number 18, A. Srinivasaya.
Claimant of case of R2 IFCO Tokyo.
Srinivasaya A. Land counsel for the appellant is present. Sri D. Vijay Kumar is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri D. Vijay Kumar. Full stop. Issue notice to respondent number 1 on furnishing the requisites. List on 12th November.
Serial number 19, KL Srinivas.
Appellant in this case, not claimants appeal matter seeking enhancement of compensation. 486 days deadline filing.
Sri KL Srinivas, Land Counsel for the appellants is present.
Jagdish HT Malad on behalf of KL Srinivas. I'm Jagdish HT, please.
Sri
Jagdish HT
Jagdish HT
on behalf of KL Srinivas.
representing Sri KL Srinivas, Land Counsel on record for the appellants is present.
R2 Malad United Indians.
Srimati Geeta Raj is called upon to accept notice for respondent number 2 and file wakalat subject to the entrustment of the case otherwise by respondent number 2. Appellants to serve copies of appeal papers at the chambers of Srimati Geeta Raj.
Please.
Issue notice to respondent number 1 on furnishing the requisites. List on 19th November.
Serial number 20.
Same. Claimants appeal matter seeking. Respondent number 2 Malad National Insurance Company.
Third, same Sri Counsel, Land Counsel who represents Sri KL Srinivas, Land Counsel on record. Sri C. Shankar Reddy is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri C. Shankar Reddy. Issue notice to respondent number 1 on furnishing the requisites. List on 19th November.
Please. 21.
Serial number 21.
Same, no? Same sentence.
R2 IFCO Tokyo General Insurance.
Sri B.C. Shivanagoda is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri B.C. Shivanagoda. Issue notice to respondent number 1 on furnishing the requisites. List on 19th November.
Please.
Serial number 22, L. Bhagirathi.
For the appellant in this case, my lord, there is a delay in filing 73 days appeal for due to the death of the first.
For Mr. Bhagirathi.
No, my lord, my colleague,
Your good name, Mr. Counsel.
Bojraj.
Huh?
Bojraj.
Bodharaj. Sri Bodharaj, representing Sri Bhagirathi L, Land Counsel on record for the appellants is present.
United India.
Sri Shaila S is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Issue notice to respondent number 2 on furnishing the requisites. List on 26th November.
Serial number 23.
My lords, I'm for the
Harish
appellant, my
NR.
lords. I'm for the appellant, my lords. My lords, this is the case of death, my lords, where the dependents have filed this appeal. My lords, there is questionability of liability, my lords. So
Let us-
therefore, notice may be issued to both the respondents, my lords.
Heard Sri
Shreyas and my lords.
Sri Shreyas N, Land Council representing Sri Harish NR, Land Council on record for the appellants is present.
United.
Sri L. Srikanta Rao is called upon to accept notice for respondent number 2 and file wakalat subject to endorsement of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellants to serve copies of appeal papers at the chambers of Sri L. Srikanta Rao. Issue notice to respondent number 1 on furnishing the requisites. List on 26th November.
Serial number 24.
My lord, I'm the appellant in this case as well. This is also a death case, my lords. So, so far as the respondent 1 may be dispensed with, my lords.
You are filing memo now?
Please, my lords.
Sri Shreyas N, Land Council representing Sri Harish NR, Land Council on record for the appellant is present. Land Council files memo seeking dispensation of notice upon respondent number 1. Full stop. Land Council states that as liability is fixed upon respondent number 2, comma notice to respondent number 1 may be dispensed with. Full stop. Having considered the submission thus made, comma notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
Deeply obliged.
Sri Janardhan Reddy is called upon to accept notice for respondent number 2 and file wakalat subject to endorsement of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri Janardhan Reddy. Next, issue notice to respondent number 3 on furnishing the requisites. List on 26th November.
Grateful, my lords.
Serial number 25. D. Vijay Kumar.
My lord, I am for the appellant, my lord. This appeal is by the Reliance General Insurance Company. My lord, challenging the liability, negligence and quantum of compensation. It is an unregistered vehicle. There is no policy and driving license.
Let us
That
issue
vehicle
notice,
met with
Mr.
an
Counsel.
accident.
Let us issue notice.
Please, my lord, stay may be granted, my lord. Kind.
There
I am
is
ready
no
to deposit 50% of the award amount
No,
before I
Mr.
could.
Counsel, we cannot grant any stay. The delay is 855 days.
My lord, even ready to deposit 100% amount before this honorable court.
Heard,
My lord,
Sri
may I make one submission, my lord? May, actually, the mistake is by the trial court advocate. My lord, he has not forwarded the certified copy. My lord, we don't want to make any allegation against our brother.
Notice be served, Mr. Counsel. Heard, Sri D. Vijay Kumar, Counsel for the appellant who appears through VC. Full stop. Issue notice to respondents in the appeal as well as in IA 1 of 2024 and 2 of 2024 on furnishing the requisite. List on
Emergent
26th
notice may be ordered, my lord.
List on 26th November.
Emergent notice may be ordered.
There is no such thing in CPC, Mr. Counsel.
Please, my lord.
Serial
Because
number
this is the
26.
practice in the Honorable High Court, my lord. That's why I make submission.
Serial number 26. Shivkumar P. Karnataka Gowda.
Representing P. Shivkumar. The on-record counsel has expired in the last 2 weeks' time will be granted.
It is reported that Sri Shivakumar P. Land Council on record for the appellant is no more. Full stop. Therefore, registry is directed to send notice to the appellant. Remove from the caption dismissal and list under the caption for orders. List on 29th October.
Serial number 27. Syed Abdul Sabur.
I am for appellant in this case, my lord. It's a injury, my lord. New India Assurance, my lord.
Three, Syed Abdul Sabur, Land Counsel for the appellant, appears through VC. Sri A. Ravishankar is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri A. Ravishankar. Issue notice to respondent number 1 on furnishing the requisites. List on 3rd December.
Serial number 28, yes, Raju.
For the appellant, filing a memo for dispensation of R1.
Sri Raju, yes, Land Counsel for the appellant is present. Land Counsel files memo seeking dispensation of notice upon respondent number 1. Why it should be dispensed with, Mr. Counsel?
Liability accepted by the trial insurance.
Sri Raju, yes, submits that as respondent number 2 admitted its liability, notice to respondent number 1 may be dispensed with. Having considered the submission thus made, notice to respondent number 1 stands dispensed with, however, at the risk of the appellant.
United Insurance.
Next. Sri Ravish Benny is called upon to accept notice for respondent number 2 and file wakalat subject to entrustment of the case otherwise by respondent number 2. Appellant to serve copies of appeal papers at the chambers of Sri Ravish Benny. List on 26th November.
Refer to Lokadat.
You want you remove. At request of Sri Raju, yes, the matter is referred to Lok Adalat for settlement.
Serial number 29, Harish NR.
My lords, and for the appellant, my lords, filing a memo for dispensation for R2. This is a case of injury, my lords. R1 is the insurer, R2 is the respondent of the offending vehicle, my lords. United.
Shreyas, yes, representing.
Shreyas N, sorry, my lords.
Shreyas N, representing Sri Harish NR, Land Counsel on record for the appellant is present. Land Counsel files memo seeking dispensation of notice upon respondent number 2. Land Counsel states that as respondent number 1 admitted its liability, notice to respondent number 2 may be dispensed with. Having considered the submission thus made, notice to respondent number 2 stands dispensed with, however, at the risk of the appellant.
United Invention.
Sri P.B. Raju is called upon to accept notice for respondent number 1 and file wakalat subject to entrustment of the case otherwise by respondent number 1. Wakalat to be filed within 2 weeks. Appellant to serve copies of appeal papers at the chambers of Sri P.B. Raju.
Please, my
List
lords.
on 3rd December.
Deeply obliged, my lords.
Serial number 30, Ashok N. Patil.
Case, insurer appeal, not challenging liability. Not the driver on the wheels, did not have the valid and effective driving license. The charge sheet is also laid under section 3(1) read with 181 and section 5 and 180. Absolute liability is fastened on the insurer. The other ground is that the accident took place because of the negligence of the injured, and 50-50 is held now. I am seeking on the count of liability and negligence.
Heard. Sri Ashok and Patil, learned counsel for the appellant. IA-1 of 2024 is filed, seeking the court to stay the operation of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 1336 of 2019, dated 1/6/2024. Full stop. Learned counsel Sri Ashok and Patil submits that the insured violated the terms and conditions of the policy, and therefore the appellant is not liable to pay any compensation. Full stop. However, the tribunal fastened liability to the extent of 50% against the appellant, and therefore he preferred the appeal. Full stop. Having considered the submission thus made, this court is of the view that stay as prayed for is required to be granted. Full stop. Hence, the execution of the award that is passed by the Motor Accidents Claims Tribunal, Bangalore, in MVC 1336 of 2019, dated 1/6/2024, shall stand stayed until further orders on the petitioner appellant depositing 50% of the award amount along with accrued interest before this court within a period of 4 weeks. Next, on such deposit, the appellant is the registry is directed to invest the same in any interest yielding fixed deposit scheme of any nationalized bank until further orders. Next, issue notice to respondents in the appeal as well as in IA-1 of 2024 on furnishing the requisites. List on 3rd December.
Please.
Admission matter, serial number 31, Prakasha HC, B. Pradeep for R2.
Kindly pass over.
Huh?
Senior is in another court. Kindly pass over them.
Pass. Serial number 32, Shripad V. Shastri.
My lord, I am for appellant, but in this case, my lord, Tata AIG R1 is already served. R2 notice to R2 may kindly be dispensed with, my lord.
Already dispensed with Mr. Counsel.
My lord, Tata AIG R1 served. Any panel advocate may kindly be directed to
Already
take.
served. They did not turn up. Why should we grant to Tata AIG? Notice is served. They did not take it. Yes. Heard, Sri Shripad V. Shastri, learned counsel for the appellant who appears through VC. Admit. List the matter and the caption final hearing on 29th October.
Serial number 33, K. Prasanna Shetty, Ravi S. Samprati for R2.
Appear for appellant, my lord. Refer to other.
Serial number 33, R. Shashidhara.
Appear for appellant, my lord. Refer to Adalat.
Miss Geetanjali,
Yes.
representing Sri R. Shashidhara, learned counsel on record for the appellant, seeks to refer the matter to Lok Adalat. Hence, the matter is referred to Lok Adalat for settlement.
Serial number 34, K. Prasanna Shetty.
I appear for the second respondent.
Ravi S. Samprati.
This matter also can be placed before the Lok Adalat. Case of death, he was aged around 70 years.
At request of Sri Ravi S. Samprati, learned counsel for respondent number 2, the matter is referred to Lok Adalat for settlement.
Serial number 35. R. Shashidhara, Ravi's Samprati.
Appear for appellant, my lord, refer to local.
Opponent.
At request of Ms. Geetanjali, land counsel who represents Sri R. Shashidhara, land counsel on record for the appellant, the matter is referred to local adelaide for settlement.
Serial number 36. Raja Subramanya Bhatt, C. Shankar Reddy, or respondent. Serial number 36.
No representation on either side on call. In both the appeals. Full stop. To give fair opportunity. List on 23rd October.
Serial number 37. Prakash Ahetsy, SV Hegde Mulkund for response.
Kindly possible.
Pass over. Serial number 38. Ravi Shankar Samprati,
Appear for the appellant.
Basavaya
Records-
C for respondent.
Records are required. The defense of the insurance company is that the check was bounced and the policy was cancelled.
Heard, Sri Ravi S. Samprati, land counsel for the appellant. No representation on respondent side on call. Admit. Call for the records from the consent tribunal. List the matter under the caption final hearing on 12th November.
Obliged.
Serial number 39. Girish B. Baldare, B.S. Krishna for R2.
Appear for business. Yes. It's put on. The case of injury, my lordship. Accident occurred on 18/4/2018. When the petitioner was proceeding in a motorcycle, while turning the motorcycle due to rash negligence of the car driver, the alleged accident has been taken place. And the tribunal awarded the compensation by taking the income on lower side. And no compensation is awarded under the head of amenities and other heads. And without any cogent reasons, they have shifted the 25% of contributory negligence on the two-wheeler, my lordship, that is a bike, in which the claimant was going as a pillion rider. There are no contra evidence led by the insurance company to attribute 25% contribute negligence against the motorcycle. In spite of the same, the tribunal fashioned the 25% contributed negligence on the two-wheeler, my lord. That aspect has to be set aside. And compensation is deserved to be enhanced, my lord. The findings recorded with regard to the contributed negligence in page number para 16 of the judgment. And while issue number 1, answering issue number 1, it is clearly held that it is an affirmative. And observed that due to rash negligence driving of the driver of the car, the accident has took place. But in the operative portion, shift the burden of 25% as a contributing negligence on the two-wheeler, my lord.
So he sustained comminuted fracture of femur.
Yes, my lord. And income taken by the tribunal is on lower side. Instead of taking 12,500 as per the local Adalat chart, only 9,000 income is taken by the tribunal. And no compensation awarded towards amenities and inpatient for the period of 7 days. And towards loss of income during laid-up period and attendance charges are on lower side, my lord.
What was his occupation?
He states to be a plumber.
Agriculture and plumber, my lord.
What is that?
And he was exhibit P13, my lordship, a document has been furnished by the claimant. Exhibit P13. Issued by the authority concerned.
Regarding what?
Building association has has issued the certificate as is the member of that association. Building Construction Association, Labor Association. So that
loss of future income comes to 2,47,500. If notional income is taken at 12,500,
and towards amenities, no compensation is awarded.
let us see.
Comes to?
2,47,500. That is 12,500 into 12 into
Mr.
15.
Council, we'll do the calculation. What is your submission with regard to the
Contributory negligence. You, my lords, the finding is proper because it is an admitted fact that the injured was riding. He was the rider. He was driving the motorcycle, and in broad daylight, and there was he takes right turn without observing the vehicle that is coming on the opposite side. That car was coming on the opposite side, which was very clearly visible, but to on a highway. Your lordships are very well aware that if it is on a highway, that to a national highway, contributory negligence will have to, the courts have taken the contributory negligence at 40%. First point is he does not observe the vehicle that is coming on the opposite side, number one. Number two, he holds no driving license at all. This driving license can be construed that he did not know the driving at all. Even if it is otherwise, merely not holding driving license will not amount to negligence on the part of the rider. But on a highway, when the vehicle was coming on the opposite side, without looking into that, if he suddenly takes right turn, then he has contributed in negligence resulting the accident, is my humble submission. For that purpose, may I request your lordships to kindly peruse the finding that is given. The court has rightly come to the conclusion based on several well-decided judgments at 20% as the contributory negligence. Your Honor may kindly see page 15 of the judgment.
Yes.
Yes, your lordship has seen. Though the petitioner may submit.
Yes, Mr.
Yes. Here, the accident, I'm reading from the third line in para 15 from the top. Accident took place about 2:30 PM, that is in daytime. Though the petitioner has stated that he had taken turn by showing the indicator, as it was daytime, petitioner who has seen the car coming from Begur side would have waited till passing of the car to take turn towards the right side. Though the evidence before the court and the investigation records clearly show that the car was rashly and negligently driven, and then it dashed to the motorcycle, which was taking a turn towards the right side. The act of the petitioner also show some part of negligence of the petitioner as cause for happening this accident. Therefore, apparently, there is contributory negligence of the petitioner riding the motorcycle without having driving license and taking right turn towards taking turn towards right side in the daytime without waiting for the opposite vehicle to pass. Therefore, out of the compensation amount decided, the above certain amount is to be deducted towards contributory negligence. And the honorable, the court, the honorable tribunal, in para 15 and 16 considers the various judgments on this point and arrives that 20% is the contribution regarding the negligence which is attributed. In the circumstances, my humble submission is, it is not disputed that it is a highway. In this, your lordships are aware that in the highway, the riders and one and all will have to have some caution, show some caution. And on this point also, your lordships are aware of several judgments. And based on these judgments, the tribunal has rightly come to the conclusion that the rider has also contributed to the extent of 20%. That is why that is insofar as contributory negligence is concerned. And notional income ought to have been taken at 12,500. And multiplier taken is appropriate, it is correct. And towards later period, the honorable tribunal has granted 15,000 on the premise that he needs rest for 1.5 months.
Yes, Mr. Counsel. So far as contributory negligence on part of the appellant is concerned, we are in disagreement with the findings given by the tribunal, and therefore the insurance company is liable to pay the entire amount. So far as amount that can be awarded as compensation is concerned, for pain and suffering 30,000, medical expenses 1,09,000, attendant charges 10,000, food and nourishment 10,000, loss of earnings during later period 37,500, loss of future earnings 3,46,500, future medical expenses 30,000, transportation charges 5,000. Total it comes to 5,78,000.
My lords, so far as the contributory negligence, your lordships have retained the order of the tribunal, my lord.
No,
Yes, ma'am.
we have set aside the order of the tribunal. Heard. Sri Girish P. Baldari, Land Counsel for the appellant, as well as Sri B.S. Krishna,
Yes, ma'am.
Land Counsel for respondent number 2 insurance company. Next. Challenge in this appeal is the order that is rendered by the additional motor accidents claims Tribunal Hassan in MBC 1676 of 2018, dated 18/11/2019. Full stop. On hearing Sri Girish P. Baldari for appellant, B.S. Krishna for respondent number 2, comma, the two points that are required to be discussed and decided are as under. 1. Whether the appellant contributed for the accident to occur as observed by the tribunal. Next. Whether the compensation awarded by the tribunal is just and reasonable, and if not, to what amount the appellant is entitled to. The appellant moved an application seeking compensation of rupees 10 lakhs in total. Full stop. The tribunal, through the impugned order, held that the compensation which the appellant is entitled to is 3,67,000. Full stop. However, giving a finding that the contributory negligence on part of the appellant is 25%, comma, directed the respondents to pay Ma'am, 20%, not 25%. 20%. To pay a sum of rupees 2,94,000. Next. The manner of happening of accident as projected by the appellant before the tribunal is that on 18/4/2018 at about 2:30 p.m. while the appellant was proceeding on his motorcycle on Hassan Vellur Road, and when he reached Manachanahalli, comma, he attempted to turn right by showing indicator, and while he was turning his bike, comma, a car bearing registration number KA18P 3111, which came from Belur side, dashed against his bike and that the car was driven by its driver in a rash and negligent manner, due to which the accident occurred. Full stop. Arguing the matter, learned counsel Sri B. Sri Girish P. Baldari submits that though the tribunal dealing with issue number 1 with regard to rash and negligent driving of the driver of the car gave a finding in affirmative and held that the accident occurred due to the rash and negligent driving of the driver of the car. Full stop. However, after discussing about the quantum of amount which the appellant is entitled to receive as compensation, again gave a finding that the contributory negligence on part of the appellant is 20%, which is improper. And counsel Sri Girish P. Baldari submits that without there being any evidence on record to show that the appellant was negligent, the tribunal attributed contributory negligence, which is unjustifiable. Next bill. Contradicting the submission thus made, Sri B.S. Krishna and counsel for respondent number 2 contends that the appellant was not holding driving license to drive the bike, and indeed the accident occurred due to his negligence. Having perceived the fact of manner of happening of accident, the tribunal rightly fastened the liability against the rightly fastened the liability against the appellant also, and therefore the observations made by the tribunal with regard to contributory negligence needs no interference. Next. It is not in dispute that the material available before the tribunal to decide the aspect of negligence is the evidence of PW1 and exhibits P1 to P6 alone, P1 to P7 alone. Next. The evidence of PW1 and exhibits P1 to P7 goes to show that the accident occurred due to the rash and negligent driving of the driver of the car.
With permission, only one sentence I may be permitted.
Yes.
Yes. This exhibit P6 is the mahazar, which the sketch is also there, which shows that the rider was attempting to take right turn at 2:30 p.m. Now, apart from the driving license, his attempt to take right turn without observing the opposite vehicle, that is one thing. And the cross-examination of PW1, it is, he admits that the vehicle was, this car was coming from the opposite side.
We'll discuss everything.
Yes, yes, that's all.
Car, full stop. The owner of the car, for the reasons best known, did not contest the case. Full stop. No attempt was made by respondent number 2 insurance company either to produce the evidence of the driver of the car or any other witness who can depose about the manner of happening of accident. Full stop. The fact that the police, after investigation, laid charge sheet against the driver of the car is not in dispute. Full stop. Thus, there is no material on record. There was no material on record before the tribunal to infer that the appellant contributed for the accident to occur. Full stop. Also, as rightly contended by Sri Girish P. Baldari, the tribunal at para 14 of the impugned order gave a clear finding that the evidence before the court and the investigation clearly shows that the driver of the car drove the car in a rash and negligent manner. Full stop. Such being the situation, this court is of the view that only because the appellant did not produce his driving license, he cannot be held to be negligent. Full stop. Therefore, this court holds that the observations made by the court, by the tribunal, with regard to attributing contributory negligence on part of the appellant are required to be set aside. Full stop. Next. Coming to the quantum of amount that is awarded as compensation, the version of the appellant is that as plumber and by doing agriculture, he was earning rupees 30,000 per month. Full stop. However, no substantive proof was produced by the appellant in proof of his occupation and earnings by the date of accident. Full stop. However, the submission made by Sri Girish P. Baldari that the accident occurred in the year 2018 and for the relevant period, even the Karnataka State Legal Services Authority is taking the notional income as rupees for 12,500 per month, and the same figure is required to be taken, is not denied by Sri B.S. Krishna and Counsel for Respondent number 2. Full stop. Also, the said request appears justifiable. Next. The age of the appellant admittedly was 36 years by the date of accident. Full stop. This court does not find any grounds to interfere with the observation made by the tribunal that the disability in respect of whole body is 11%. Full stop. Having considered the age of the appellant as 36 years by the date of accident, 40% of the actual earnings are required to be added towards future prospects as per the decision of the Honorable Apex Court in Pranay series. Full stop. Also, the appropriate multiplier to be applied is 15 as per the judgment of the Honorable Supreme Court of India in Sarla Verma's case. Full stop. Thus, the loss of future earnings due to permanent physical disability is as under tabular form. Notional monthly income 12,500, annual income 1,50,000, add 40% towards future prospects 2,10,000, apply appropriate multiplier 15, 31,50,000, loss of future earnings, permanent physical disability being 11%. 3,46,500. Full stop. Next one. Thus, the appellant is entitled to a sum of rupees 3,46,500 towards loss of future earnings on account of permanent physical disability. Full stop. The appellant admittedly sustained comminuted fracture of femur, comminuted fracture of left femur, which is grievous in nature, and also sustained a simple injury. Full stop. It is clearly brought on record that the appellant was admitted at NDRK hospital for treatment, and he took treatment as inpatient for about 7 days. Full stop. It is not in dispute that the appellant underwent a surgery during the course of treatment. Full stop. Having considered the nature of injuries sustained and the treatment taken, this court is of the view that the appellant would not have attended his normal pursuits at least for a period of 3 months. Full stop. Thus, the loss of earnings during later period comes to rupees 37,500 within brackets 12,500 into 3. Full stop. So far as award of rupees 30,000 under the head pain and suffering, 1,09,000 under the head medical expenses, 30,000 towards future medical expenses is concerned, the grant is justifiable. Full stop. However, the amount granted under other heads requires slight enhancement. Full stop. So this court is of the view that the appellant is entitled to a sum of rupees 5,000 towards transportation charges. Full stop. Thus, the total compensation which the
I make one
appellant is
submission,
entitled
amenities is not awarded.
is as under. Next, compensation for pain and suffering, 30,000. Medical expenses, 1,09,000. Attendant charges, 10,000. Food and nourishment, 10,000. Loss of earnings during later period, 37,500. Loss of future earnings, 3,46,500. Future medical expenses, 30,000. Transportation charges, 5,000. Total 5,78,000. In the light of the foregoing findings, the appeal is disposed of with the following note. The appeal is allowed in part. The don't type the contributory negligence attributed on part of the appellant is set aside. Next, the appellant is entitled to a sum of rupees 5,78,000 as compensation. Full stop. Respondents 1 and 2 are jointly and severally liable to pay the amount awarded. Full stop. Next, the compensation granted carries interest at the rate of 6% per annum from the date of petition till the date of deposit. Next, the second respondent is directed to deposit the entire sum within a period of 8 weeks from the date of receipt of copy of this order. Next, on such deposit, the appellant is permitted to withdraw the entire amount.
My lord, out of the 5,78,000, the all amount deposited needs to be deducted.
You have deposited any
Yes,
amount?
yes.
Rest of the amount you have to deposit.
Is that
Yes. There's no need of passing any order.
ಡಿಡಕ್ಟ್ ಮಾಡೇ ಕೊಡ್ತಾರೆ.
That will be deducted. That should
Deposit
be
total, they are entitled for total sum of rupees 5 lakh something.
deducted. Yes.
Serial number 40.
For petitioner, kindly pass
for HC.
Senior is
Sambula Tejasvi.
Kindly pass over.
Yes. Pass.
Serial number 41. Guru Prasad BR, A Ravi Shankar for R2.
Please, my lords, I appear for the appellant.
Yes.
My lords, it is a case of death. My lords, on two grounds, my lords, we are challenging this impugned order, my lords. One is enhancement, my lords. This is a claimant's appeal. Second ground is that, my lords, the insurance company has been exonerated from its liability. That's also we are challenging, my lords.
We'll admit and list for final hearing, Mr. Khan.
Please, my lords.
Heard, Sri
Guru Prasad.
Guru Prasad BR, Land Counsel for the appellant, as well as Sri
Ravishan.
A Ravi Shankar, Land Counsel for respondent number 2. Admit, list the matter and the caption final hearing on 23rd October,
24th.
24th October.
Serial number 42. Kailash Shankar, K Nagarajaya for
For
R2.
the second respond, my lord. Case for enhancement, only quantum is. The accident is occurred on 15/10/2019, my lord. And claimant is aged 19 years and he professionally electrician. And he sustained decloving injury of left leg and
What
foot.
to do, Mr. Counsel, when the entire award is in, order is in Kannada language?
Sorry, my lord.
Appellant is heard Sri Kailash Shankar PS, Land Counsel for the appellant, as well as Sri K Nagarajaya, Land Counsel for respondent number 2. Admit. Appellant is directed to file translated copy of the impugned order as well as the documents which he relies upon. List on 23rd October. Under the caption final hearing.
Serial number 43. Pal Krishnayan.
For respondent number 5 in this case, my lord. For the insurance company, my lord.
Appear for the claimant's appeal for enhancement. Case of
My
death.
lord, kindly pass over, my lord.
I was only two grounds for enhancement.
Kindly pass over, my lord.
Why pass over, Mr. Counsel?
My lord, senior is on the way, my lord.
Yes.
Isn't
Next matter, kindly be report to local.
Yes.
Pass over. Serial number 44.
Much of it.
This matter may kindly report to local.
Sri Gopal Krishna N, Land Counsel who represents Srimati Susmita G, Land Counsel on record for the.
My lord, I am for the respondent, my lord.
The matter is referred to Lok Adalat for settlement.
Please, my lord.
45 adjourned. Serial number 46. Jagadish HT. BC Shivannegowda.
For R2, my lord.
And for the appellant in this case, first case, Malada. Insurance company also filed an appeal, Malada, connected matter. Respond number 2.
Insurance company appeal is also connected with this. Yes.
Let liability is question, Malada. Respond number 2 for connected matter, Malada. Respond number 2 is dead, Malada. And MFA 1061 of 2000.
Respondent number 2 is?
Dead, Malada. In insurance company appeal. First one.
1 week time may be granted, my lord. I will take steps, ma'am.
46.1.
Girish.
You are for the appellate.
First case, Malada, I am for the appellant in this case.
Madam.
Second.
Second name,
Rashmi MS.
Srimati Miss Rashmi, representing Sri BC Shivannegowda.
Right,
Land Counsel
Madam.
on record for
Okay,
the
thank you.
appellant in MFA 1060 of 2023. This time submits that respondent number 2 is no more, full stop. 6 time to bring the legal representatives of. It is a form.
Respond number one.
It is a form.
My lord.
No. Respond number one is the climate malad in the insurance company matter malad.
Number one is.
No more.
No more, is no more.
Should
No.
also.
My appeal malad, my appeal papers malad. Connected matter, 46.1 malad.
In 46.1.
46.1.
The appellant is the insurance.
Insurance company, appellant is the insurance
Yes.
company.
So who died?
Respond number one.
Respondent number one, not respondent. Seeks time to bring the legal representatives of respondent number one on record.
Please.
Hence, list MFA 1060 of 2023 along with connected matters on 30th October.
Please. Meanwhile, malad, call for TCR malad.
Call for the records from the consent tribunal in the meantime.
Please.
Serial number 47, 48 adjourn, 49 Nagaraj Hegde.
Here for appellant, kindly Swami on the adjournment ಕೊಡಬಹುದು. ನಮ್ಮ ಸೀನಿಯರಿಗೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಿದೆ. 2 weeks adjournment ಕೊಡಬಹುದು.
English ಅಲ್ಲಿ ಹೇಳಿ.
Your good name?
ಗಣೇಶ್ ಭಟ್.
Sri Ganesh Bhatt, representing Sri Nagaraja Hegde, Land Council on record for the appellants in both the appeals, seeks time. Hence, stand over to 25th October.
Serial number 50 adjourn, 51 D Vijay Kumar, Nanesh Kumar K for.
My lord, I am for the appellant, my lord. Other side, I am ready.
Will admit and list for final hearing.
Please, my lord. Or it can be called at 2:30 also.
2:30, yes, we'll pass over the matter.
Please, my lord.
There is no representation for the other side, Mr. Vijay Kumar.
KH Nanesh Kumar for
Next week,
R1.
my lord. Next week, my lord.
Heard Sri D. Vijay Kumar, Land Council for the appellant who appeals through VC. Admit. List the matter under the caption final hearing on 25th October.
Please, my lord.
52 adjourn, 53 K Shantraj, D Vijay Kumar for R2.
My lord, I am for the respondent, my lord.
Serial number 53
No representation on appellant side on call. Sri D. Vijay Kumar, Land Council for respondent number 2 appears through VC. To give fair opportunity to the appellant to pursue the matter, list on 20th November.
Much obliged.
54 adjourn, 55 P Mahadev Swami, BC Shivanegowda.
Here for appellant, my lord. Case of death for seeking enhancement, my lord. The deceased Hemant Kumar, aged about 44 years. The claimants are wife, children and parent, my lord. Lord, in this case, my lord, only for quantum of compensation, my lord. The deceased was working as supplying construction materials. His own lorries, my lord. He is earning rupees per 1 lakh rupees per month, my lord. And he is income tax assessee.
Who are the claimants?
Claimant, my lord, wife, children and parent.
Mother, not parent.
ರಂಗಮ್ಮ ಒಂದು ನಿಮಿಷ ಇದು ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ಫೈಲ್ ಮೇಲೆ ಬರ್ದ್ಬಿಡಿ ಒಂದು ನಿಮಿಷ ಏನಾಗಿದೆ ಅಂತ ಬರ್ದ್ಬಿಡಿ ಅದ್ರ ಮೇಲೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
So the wife, children and mother.
Mother, 4 members.
Yes.
My lord, as per the evidence, my lord, the deceased was doing a business supplying construction materials and his own vehicle lorries, my lord. He's earning rupees 1 lakh per month, my lord. In para number issue number 2 of the judgment, para number 12, my lord. the registration certificate and income tax returns, returns for assessment of in the year 2028, 29, 29, 20, 20, 18 to 18 and 19, 19 and 20, 20 and 21, my lord.
Yes, Mr. Council, the income was taken, monthly income was taken as 29,143.
143.
Yes.
My lord, in the income tax returns, my lord, he is earning rupees 4 lakhs 25,400 in the year of 2018 and 19, my lord. In the year of 2019 and 20, my lord, 4 lakhs 36,062 rupees, my lord. Gross income, my lord. The trial court considered total income. The deduction was not considered.
Record received.
Yes.
Exhibit P12 to 15. The trial court has considered 2019 and 20 income tax returns, my lord. In the year of 2019 and 20, my lord, he is earning rupees 4,36,062 rupees. Sir. And deduction, my lord, 86,340 rupees. The trial court considered only of 3,49,720, my lord. Income tax return. ಅದಕ್ಕೆ ಎಕ್ಸಾಮ್ಷನ್ ಕೊಡೋದಿಲ್ಲ.
So your income was 4,36,062
rupees. The trial court considered for 3,49,730.
But it should be 4,35,009 rupees.
Yes.
Photo please. Where is?
6%. Yeah, 6%.
Yes, Mr. Council.
Only that ground, my
We
lord.
take the income as 4,35,009 rupees.
Yes, my lord. In other rates, my lord, the 40,000 rupees each, lots of consortium and lots of
It is
estate
granted.
50,000 each.
40, it is granted, my lord. Only under that head,
So age was 44 years.
44 years, 25% for future prospect.
Multiplier is 14.
Yes, ma'am.
Deduction is 1/4.
Please. 1/4, ma'am. 1/4. 1/4.
The annual income is 4,35,009 rupees.
4,36,092 rupees.
No, 4,35,009 rupees.
As per the exhibit, the 2019 and 20, my lord.
They have added the interest of 1,000 and odd.
Please. Yeah.
That should not be added. So
Yes, ma'am.
4,35,009
Okay.
rupees. You add 25% to it,
For future.
which will it come?
Calculate.
4,35,009 rupees, 4,35,009.
1,08,752.
That is added, how much will it come?
Blood. Four.
Here, the annual income is 4,35,009 rupees.
Correct.
We have to add 25% and we have to deduct 25%.
Please.
So the same figure should come.
25%. Same figure is.
Should come, but
Yes, ma'am.
same figure is not coming.
20% no, adding that, my lord, 1/3 has to be. 1/4 has to be.
1/4, 1/4.
1/4. Same amount is come.
So same amount should come, but it is not coming.
Correct, very same amount is. Same amount is coming.
It is not coming. And adding 25%, it comes to rupees 5,43,761. On deducting 1/4, it is coming 4,07,821.
4,07,000.
And how it is happening?
That.
So, yes. Heard. Heard Sri P. Mahadeva Swami, Land Counsel for the appellants, as well as Sri B.C. Shivanagowda, Land Counsel for respondent number 2. Seeking enhancement of compensation, the claimants in MVC 3823 of 2020 that stood pending before the Motor Accidents Claims Tribunal, Bengaluru, are before this court disputing the order dated 30/8/2022. Full stop. As against the claim for 40 lakhs in total, the tribunal through the impugned order awarded a sum of rupees 47 lakhs 80,100 as compensation. Full stop. Next, the short point involved as submitted by Sri P. Mahadeva Swami, Land Counsel for the appellants in this case, is with regard to the income of the deceased Hemant Kumar. Full stop. The appellants are the wife, two minor children, and the mother of the deceased Hemant Kumar. Full stop. As per the version of the appellants, the deceased Hemant Kumar, by maintaining his own lorries and by supplying construction material, was earning rupees 1 lakh per month. Full stop. The appellants produced income tax returns for the assessment years 2018-19, 2019-2020, and 2020-21. Full stop. Making an observation that for the assessment year 2020-21, the returns were filed after the death of Hemant Kumar. Hence, the tribunal took into consideration the income tax returns for the assessment year 2019-2020. Full stop. Taking into consideration the returns of the assessment year 2019-2020, the tribunal took the annual income of the deceased as rupees 3,49,720. Full stop. However, as rightly projected by Sri P. Mahadeva Swami, for the assessment year 2019-2020, the income of the deceased Hemant Kumar was rupees 4,35,009 rupees, 435,009. Full stop. The tribunal deducted the tuition fees paid. The tribunal deducted the premium paid towards life insurance and other deductions. Full stop. However, as the document reveals that for the assessment year 2019-2020, the income was declared as 35,009 rupees. This court is of the view that the said figure is required to be considered for assessing the amount that is required to be awarded under the head loss of dependency. Full stop. Learned Counsel Sri B.C. Shivanagoda did not deny the submission made by Learned Counsel Sri P. Mahadeva Swami in this regard. Full stop. Next page. Taking the annual income of the deceased as rupees 4,35,009, the deceased as the deceased Hemant Kumar died at the age of 44 years, adding 25% of the earnings towards future prospects, deducting 1/4 of the earnings towards personal and living expenses, which the deceased Hemant Kumar would have incurred for himself had he been alive, applying appropriate multiplier 14, the amount that is required to be awarded under the head loss of dependency is as under. Tabular formula. Annual income 4,35,009. Add 25% towards future prospects. 5,43,761.25. Deduct 1/4 towards personal and living expenses. 4,07,821.07,821. On applying appropriate multiplier 14, loss of dependency is 57,09,494.
That's 68 lakhs, 51,388.
68 lakhs.
68 lakh 51,000.
Multiplier is 14.
14.
No.
Well,
It will be 68 lakhs.
total amount, my lord.
Annual income is 4,35,009 rupees.
Correct.
Adding 25% towards future prospects, 5,43,760.
761 into 12 into 14 and 1/4 month.
Into 12.
Oh, sorry, my lord. Wrong calculation.
That is annual income.
Sorry. Wrong calculation.
Yes. What did you write?
14 no, ma.
Yes. Yes. Together with the said amount, next paragraph. Thus, the appellants are entitled to a sum of rupees 57,994 towards loss of dependency. Full stop. Together with the said amount, the appellants are entitled to rupees 16,500 towards funeral expenses and 16,500 towards loss of estate. Full stop. The first appellant, being the wife of the deceased, is entitled to rupees 44,000 towards loss of spousal consent. Full stop. The appellants 2 and 3, being the children of the deceased, are entitled to rupees 44,000 towards loss of parental consortium. Full stop.
Mother.
The fourth appellant, being the mother of the deceased, is entitled to rupees 44,000 towards loss of filial consortium. Full stop. Thus, the compensation which the appellants are entitled to is as under. Loss of dependency 57,09,494. Loss of estate 16,500. Funeral expenses 16,500. Loss of spousal consortium 44,000. Loss of parental consortium 44,000. Loss of filial consortium 44,000. 58,74,494. Rounded to 58,74,500. The tribunal, through the impugned order, awarded a sum of rupees
47,096.
47,80,100 as compensation. Full stop. However, the justifiable sum which the appellants are entitled to is 58,74,500. Full stop. Therefore, the appeal is disposed of with the following order. The appeal is allowed in part. The compensation that is granted by the Motor Accidents Claims Tribunal, Bangalore, through orders in MVC 3823 of 2003, dated 30/8/2022, is enhanced from 47,80,100 to 58,74,494. Full stop. The enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. Full stop. The second respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. Full stop. The apportionment made remains intact. Full stop. On deposit, the appellants 1 and 4 are permitted to withdraw their respective shares. Full stop. The share that the amount that falls to the share of appellants 2 and 3 shall be invested in any interest yielding fixed deposit scheme of any nationalized bank till they attain the age of majority. Full stop. On their attaining the age of majority, they are permitted to withdraw their share along with accrued interest.
Serial number 56, Ravi Shankar Shastri,
Appellant, my lord.
Janardhan Reddy.
The matter may be referred to Lok Adalat, my lord.
At request of both the learned counsel, the matter is referred to Lok Adalat for settlement.
Please.
Serial number 57, Srinivasan MY. B.
I
Pradeep.
am for the appellant in this case, my lord.
Sri B. Pradeep has accepted notice in the month of October 2023. Till now,
Please.
wakalat is not filed.
Please, my lord.
Sri Srinivasan MY appears through VC. Full stop. Sri B. Pradeep accepted notice for respondent number 2 in the month of October 2023. Full stop. However, wakalat is not filed till now. Full stop. Yet to accommodate, time for 2 weeks is granted. No further time will be granted. List on 21st October.
Serial number 58, Sharadamba AR, D. Vijay Kumar.
My lord, I am for the respondent, my lord. My lord, I recently have received the copy of the appeal memo and forwarded to KSRTC. They are processing it and they are going to send the wakalat.
No representation on appellant side on call. Sri D. Vijay Kumar appears through VC and seeks time to file wakalat. Time for 2 weeks is granted. Stand over to 23rd.
Matter
October.
may be referred to Lok Adalat also.
No representation and you have not filed wakalat. Yes.
Please, my lord.
Serial number 59, Sandhya D. SV Hegde Mulkan. Serial number 59,
ಹೇಳ್ಬಿಟ್ಟೋದು ಅವ್ರಿಗೆ.
No representation on either side on call.
ಆಮೇಲೆ ಈ ಸ್ವಿಚ್ ನೋಡಿ ಗಂಗಮ್ಮ ಇದೆಲ್ಲ ಡಬಲ್ ಸ್ವಿಚ್
ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ವಿಜಯ್ ಕುಮಾರ್ ಸರ್.
24th October.
Number 60, 61 Arjan, 62 Ravish Benny, Kailash Shankar.
Negligence, 50% negligence as my submission, please. Kindly take this sketch, please. I produced this additional documents as a sketch. Kindly peruse this sketch, please.
Before seeing the sketch, my lord, this appeal is no scope. Since in connected matter, the appellant satisfied the award amount by accepting negligence and liability.
You are not questioning the negligence on the part because he is the inmate of the vehicle. He is the driver of the vehicle.
Whatever it may be, my lord. Once
Kindly, one minute, complete. Kindly take this sketch, please, now for a moment. He is coming from, ಇದು ನೇರ ಸ್ಥಳಂ ಅಂತ ಹೇಳಿ ಈ ಕಡೆ ಹೇಳ್ತಾರೆ. ಅವರು ರಾಯಚೂಟಿ ಕಡೆ he came, that disease came from the Raichur. Our driver come from the Madanpalli. Accident took place in middle of the road. ಈಗ ನಾವು ಈ ಕಡೆ ಲೆಫ್ಟಿಗೆ ಅಥವಾ ರೈಟ್ ಸೈಡ್ ಆಗಿತ್ತು, ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಪ್ಲೀಸ್ ಮ್ಯಾಮ್. ಇದು ಎಕ್ಸಾಕ್ಟ್ಲಿ ಮಿಡ್ಲ್ ಆಫ್ ದಿ ರೋಡ್ ಆಗಿದೆ. ದೇರ್ ಫಾರ್ ಸಮ್ ಕಾಂಟ್ರಿಬ್ಯೂಟರ್, he is the driver of the deceased, the driver of the ಅದು goods vehicle, please. Namdu bus, our vehicle is bus. Exactly middle of the road has taken place.
There are two cases, my lord. MVC 630 and MVC 2171. We have examined the petitioner, who is the eyewitness. He is the proceeding along with the driver as a cleaner.
One humble submission, kindly take the para 15 of the judgment, please, ma'am. He is the another petitioner who filed the MUC. He admitted in cross-examination, it is true that accident occurred in head-on collision.
Maybe it both, but they have not lead any evidence in this aspect, my lord. Even they have not lead evidence of to our is a company of share IO or any other independent eyewitness.
In this, I am requesting also kindly remand the matter, will examine the our officer and
Does not arise.
produce the sketch, please, ma'am.
This aspect does not arise.
At least 50% contributory attracts on the part of the driver of the.
Already one case is they have admitted liability and negligence. In another matter, they have no right to challenge the case.
That MUC not challenged because of he is the limits of the goods vehicle. He is the driver of the vehicle. That is only the contention, please. To some extent, contributory attracts my humble submission, please.
Mr. Counsel, at least you would have examined your driver. Why you have not examined even your driver? Yes.
Kindly peruse the sketch, please, ma'am.
Which alone cannot form basis to attribute negligence on part of the driver of the other vehicle.
Also kindly remind the matter, kindly fix the date and we'll lead the within 30 days, 60 days like this, please. It is an, there at least.
This aspect.
Three. Benny Ravish Chandrasekhar, learned counsel for the appellant, as well as Sri Kailash Shankar Prasad, Kailash
Yes,
Shankar
Shankar.
PS, learned counsel for respondents 1 to 3.
One submission, please. It will,
Quantum is a.
quantum to be reduced, please, ma'am. One third to be taken by the tribunal, to 50% to be taken. Please, admit.
This is a bachelor matter.
Unmarried.
50% has to be taken into consideration, but the tribunal taken income at 14,469. The accident is in the year of 2022, million. 15,500 has to be taken into consideration as per
Even 15,500, please, ma'am, 15,500 plus 40%, it comes to 21,700 divided by 2. It comes to 10,850 into 12 into 18, please, ma'am. It comes to total 23,43,600. Instead of 1/3 to 50% to be taken, since he is unmarried.
Is a bachelor. The claimants is the father, mother, and unmarried sister, man. Only in the aspect of income, I have challenged the.
As per the Sarala Verma case, 50% to be deducted.
What is the name of the deceased?
Venki Rao.
Venki Rao.
Venki Rao.
Venki Rao, please.
P. Venki Rao.
Claimants are parents and sister, huh?
Please, my lord. Professionally, he was a driver, my lord.
Deduction of personal expenses must be 50%, please.
Not this.
$15,500, 22. 40% comes to 6,200.
So 2022.
Please, ma'am.
It occurred in the year 2022.
22.
27/12/2022. The data of first inward.
$15,500.
Please, ma'am.
So actually, what was his occupation?
Driver and
the
third, sir,
driver-
but they
driver,
have
ma'am.
not produced. Akilala.
We are not. finished.
Not produced any DL.
Driver.
Driver, but not produced any DL, please.
And earning 25,000. We have claimed 25,000 per month, man.
Lost submission, please, ma'am. Some extent of contribution kindly consider. Because of you have not let the evidence in a connection, it cannot be. At least the 20-25% may be considered.
So the tribunal awarded a sum of rupees
30 lakhs, 26,864.
It is reduced to 24 lakhs, 20,600.
As against to 30 lakhs, please. Please.
Reduced to 24 lakhs.
No, consortium 80,000 is awarded.
Meaning it's all consortium is
Special
correct.
act
please.
not.
Funeral expenses 16,500, loss of estate 16,500, loss of consortium 44,000.
There are 3 members is there, madam.
10 members are there, we lack 4 lakhs, huh? Yes. Third. Sri Penny Ravish Chandrasekhar, learned counsel for the appellate, as well as Sri Kailash Shankar PS, learned counsel for respondents 1 to 1. Challenge in this appeal is the order that is rendered by the Motor Accidents Claims Tribunal Bangalore in MVC 630 of 2023, dated 16/2/2024. Full stop. This appeal is preferred by
There are two appeals is there.
the,
Two appeals.
ಇಲ್ಲ ನಮ್ಮ appeal ಹೇಳ್ತಾರೆ ಆಮೇಲೆ ನಿಮ್ಮ appeal ಹೇಳ್ತಾರೆ.
oh, another appeal is also there
That is a
Filed by
claimant's
the
appeal
claimants.
for enhancement.
for enhancement.
That is income purpose.
Ah,
Tribunal taken only 14,000 something.
That 15,000 now taken.
That's all.
ah. This, I remember. This appeal is preferred by the insurer of
Bus please.
the bus bearing registration number
KL 06.
KL 06E 7788. Projecting the grounds that the driver of the goods carrier vehicle which is involved in the accident was also at fault and the tribunal failed to attribute contributory negligence on part of the driver of the said vehicle. Full stop. The second ground urged is in respect of the compensation awarded. Full stop. The version of the appellant is that the sum awarded as compensation is high and excessive. Full stop. Next. The claimants also filed an appeal, that is MFA 4298 of 2024, seeking enhancement of compensation. Full stop. Thus, both the appeals are taken up for discussion with regard to merits of both the matters and disposal. Next. The manner of happening of accident, before that, for the sake of convenience of discussion, the parties to the proceedings would be hereinafter be referred to as the claimants and the insurance company. Full stop. The version of the claimants as projected before the tribunal is that on 27/12/2022 at about 4 AM, while the deceased P. Venki Rao, within brackets hereinafter be referred to as the deceased for brevity, brackets close, was driving a goods carrier vehicle bearing registration number KA08A1346 from Rayachoti towards Madanapalli, and when the vehicle reached near Star Pipe Factory, one bus bearing registration number KL0E, KL06E 7788 came at a high speed, driven by its driver in a rash and negligent manner on the wrong side of the road and dashed against the goods vehicle, due to which the deceased, who was driving the goods vehicle, caught in the seat and suffered severe injuries. Full stop. He was shifted to Government Hospital Rayachoti, and after first aid, he was referred to Sankalpa Hospital, Tirupati. Full stop. But he succumbed to injuries on the same day at about 8:30 AM. Full stop. The insurance company filed IA 2 of 2024 seeking the court to permit production of additional evidence. Full stop. Next para. Arguing the matter, learned counsel Sri Ravish Penny representing the insurance company contends that through IA 2 of 2024, the insurance company intends to bring to the notice of this court the contents of rough sketch which depicts the manner in which the accident occurred. Full stop. Learned counsel states that the said rough sketch clearly discloses that the driver of the bus was not at fault, and indeed the deceased was at fault. Full stop. Vehemently opposing the submission thus made, learned counsel Sri Kailash Shankar PS representing the claimants submits that 2 claim petitions were filed, one by the claimants herein and another by the injured
Is a cleaner in that.
seeking compensation, and in the other matter, that is in MBC 2171 of 2023, accepting the liability, the insurance company paid compensation. Full stop. Learned counsel states that both the claim petitions were disposed of by the tribunal through a common order, and when the insurance company has satisfied one part of the common order, it cannot raise different pleas and cannot take different grounds disputing its liability with regard to other part of the order. Full stop. Next page. Discussing at length the merits of the matter, the tribunal came to a conclusion that the accident occurred due to the rash and negligent driving of the driver of the bus, which is involved in the accident. Full stop. It is not in dispute that the police, after investigation, laid charge sheet against the driver of the bus. Full stop. Reasons best known, the owner of the bus did not contest the claim petitions. Full stop. Also, the insurance company did not lend any evidence in support of its plea that negligence lies on part of the deceased who was driving the goods carriage vehicle when the accident occurred. Full stop. That apart, what prevented the insurance company to file the rough sketch, which is produced before this court through IA 2 of 2024, is not stated. Full stop. Law is well settled that additional evidence cannot be accepted by the appellate court without there being cogent and convincing reasons which satisfy the court that the appellant could not produce such additional evidence despite of due diligence. Full stop. However, in the case on hand, no such grounds are projected by the insurance company. Full stop. Therefore, this court is of the view that the application filed for receiving additional evidence cannot be entertained. Full stop. That apart, rough sketch alone cannot form basis for deciding the aspect of negligence. Full stop. Next para. In the light of absence of any substantive proof with regard to negligence on part of the deceased in driving the goods carriage vehicle, the tribunal has rightly fastened liability against the insurance company. Full stop. Therefore, the observations made in that regard needs no interference. Next, coming to quantum of coming to the amount that is awarded as compensation, the tribunal through the impugned order awarded a sum of rupees 30,26,864 as compensation. Full stop. It is not in dispute that the deceased died as bachelor. Full stop. Therefore, as per the decision of the Honorable Apex Court in Sarla Verma's case, 50% of the actual earnings are required to be deducted towards personal and living expenses, which the deceased would have incurred for himself had he been alive. Full stop. However, the tribunal deducted 1/3 of the earnings. Full stop. Next. The submission that is made by Sri Kailash Shankar PS, Land Counsel for the claimants, is that the deceased as a driver was earning rupees 25,000 per month, but the tribunal took the notional income as rupees 14,469 per month, which is improper. Full stop. On the other hand, Sri Ravish Benny submits that the claimants have not produced any proof with regard to the earnings of the deceased. Full stop. Sri Kailash Shankar PS also contended that the accident occurred in the year 2022, and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 15,000 per month, 15,500 per month for settling the claims, and at least the set figure should be considered. Full stop. Sri Ravish Penny did not raise any objection to consider the notional income of the deceased as rupees 15,500 per month. Full stop. Also, the request made is justifiable. Full stop. Next, thus taking the notional income of the deceased as rupees 15,500 per month, adding 40% of the earnings towards future prospects, deducting 50% towards personal and living expenses, which the deceased would have incurred for himself had he been alive, applying appropriate multiplier 18, the loss of dependence, the amount which the appellant, the amount which the claimants are entitled to under the head loss of dependency is as under tabular form. Notional monthly income 15,500, annual income 1,86,000, add 40% towards future prospects 2,60,400, deduct 50% towards personal and living expenses 1,30,200, loss of dependency on applying the appropriate multiplier 18, 23,43,600. Thus, the claimants are entitled to a sum of rupees 23,43,600 under the head loss of dependency. Also, the claimants are entitled to rupees 16,500 towards funeral expenses and 16,500 towards loss of estate. The claimants 1 and 2, being the parents of the deceased, are entitled to rupees 44,000 towards loss of filial consumption. Thus, the compensation which the claimants are entitled to is as under. Loss of dependency 23,43,600. Funeral expenses 16,500. Loss of estate 16,500. Loss of filial consortium 44,000. Total 24,20,600. In the light of the foregoing discussion, the tribunal, through the impugned order, as earlier stated, awarded a sum of rupees 30,26,864 as compensation. Full stop. However, the claimants are entitled to a sum of rupees 24,20,600 only. Full stop. Thus, both the appeals are disposed of with the following order.
One submission, please. Amount may be transferred to the.
Yes. MFA 2609 of 2024 is allowed in part.
And you have deposited the 20.
Compensation that is awarded by the Motor Accidents Claims Tribunal, Bangalore, through orders in MBC 630 of 2023 is reduced from 30,26,864 to 24,20,600. The appeal in MFA 4298 of 2024 stands dismissed without cause.
Interest may be 6% interest.
Huh?
6% interest.
Interest.
What is the interest the tribunal awarded?
6%.
We
Yes,
don't
sir.
interfere.
Okay.
Yes. Penny in deposit, be transmitted to the consent tribunal immediately.
One submission, please. You have deposited the amount of rupees 24,20,000 through 220 before the tribunal, apart from the statutory deposit.
If there is anything you want, you have to get, you can.
Balance to be.
Serial number 63, final hearing matter, Venkatesh Som Reddy.
That's part number 3, man. It's a appear for appellant, my lords.
Special order. What is the special order? Yes.
My lords, matter may be taken up any day in next week, my lords, please.
Fine.
Senior has matter in before division bench, my lords.
Your good name?
Akshay Kumar Jain.
Sri Akshay Kumar, representing Sri Venkatesh Somireddy, Land Council on record for the appellant seeks time. Full stop. Sri C. Shankar Reddy, Land Council for respondent number 3 is present. Stop. The appeal is of the year 2014. Full stop. However, to accommodate, stand over to 23rd October.
Grateful.
Serial number 64, Sanat Kumar KM.
Appellant in this case.
The records not received.
Case of death, my lord.
Records not yet received, Mr. Council.
The last date of hearing, my lord, that this honorable court has directed, I submit that tribunal has not awarded any amount towards the.
We have not received the records, Mr. Council.
Please.
When records were called for?
No, actually records has not called for, it's only an matter has been admitted, my.
Called for on 5/9. as per office endorsement,
Please.
records were called for on 5/9/2024. Full stop. However, records are not received till now. Full stop. Registry to issue reminder. List on 25th October.
Serial number 65, adjourn 66. E. Ramesh Babu, SV Hegade Mulkund for respondent.
I appear for the insurance company in the connected matter. Because this is a case where there was no policy at all. They produced some policy number which pertains to some car, which is not a school bus. Accident is caused by a school bus. I am exonerated on the ground that fake policy has been produced before the court. This matter, in fact, was argued at length on the last hearing date. And they said they are going to produce insurance policy. They took time saying that they are going to produce insurance policy. That is why, my lords, non-filing of application is the office note. They are not prosecuting the appeal, my lords. If at all there was an insurance policy, they would have produced it by now.
On 6/8/2024, Sri E. Ramesh Babu, learned counsel for the appellant in MFA 387 of 2022, sought time to move an application for production of additional evidence. Full stop. However, no such application is moved till now, and there is no representation on appellant side. Full stop. Equally, there is no representation on appellant side in the connected appeal, that is in MFA 816 of 2022. Full stop. Sri Anuj Sri Sita Ramarao, learned counsel for respondent number 1 in MFA 816 of 2022 is present. Full stop. To give fair opportunity for the appellants to pursue the matter, list on 29th October.
Much obliged.
Serial number 67. K. Shantraj, D. Vijay Kumar for respondent.
My lord, I am for the respondent, my lord. Some announcement only under the head of conventional head, my lord.
Mr. Counsel.
My lord, I have recently received the appeal memo and forwarded to KSRTC. They are forwarding it, my lord. My lord, earlier what was happening, my lord?
There is
Most
no
of the
representation on appellant side, Mr. Counsel.
yes, I understand, because he is not feeling well, it appears.
No representation on appellant side on call. Sri D. Vijay Kumar seeks time to file wakalat. Full stop. Hence, list on 14th November.
Much understood.
Serial number 68, Prakash MH, AM Venkatesh for R2.
I am for the second respondent.
No representation on appellant side on call. Sri AM Venkatesh, learned counsel for respondent number 1 is present. Full stop. To give fair opportunity to the appellant to pursue the matter, list on 30th October 30.
Serial number 69, K. Prasanna Shetty, A.R. Lakshmi Narayana.
My lords, for the appellant, my lords.
Records not received. Call for it.
Yes,
My lords.
called on 28.
Await records from the consent tribunal.
My lords, one more submission, my lord. There are 14 other appeals connected to this common judgment, my lord.
How many?
14, my lords.
14.
Yes, my lords. Kind.
Await records from the consent tribunal. And your good name, Mr. Counsel?
Bharat Pujari.
Bharat Pujari, representing Sri K. Prasanna Setti, and counsel on record for the appellants, submits that MFA so-and-so are connected to the present appeal. Full stop. Seeks to list all the appeals on the same dates. Full stop. In the light of the submission thus made, come a registry to verify and to list the present appeal along with MFA so-and-so on 21st November.
Please, ma'am.
End submission, madam. Serial number 62, my lord. ఏంటి transfer the TCR to tribunal.
That will go, that will. Yes.
Bill number 70, Girish B. Valdare,
For appellant, my lord.
B. Vijay Kumar. for
Seeking
respondent.
I am
enhancement
for
of
the
the quantum
respondent, my lord.
of quantum of compensation awarded by the tribunal. The income taken by the tribunal is on lower side, my lordship, that has required to be enhanced.
Yes, Vijay Kumar, are you ready, Mr. Vijay Kumar?
Yes, my lord, yes, my
Yes,
lord.
we'll take it at 2:30.
Yes.
Yes.
Only regarding my lord, notional income to be enhanced, that's all.
Yes.
It
yes,
can
we'll
be
take it at
disposed of.
2:30. We'll take it at 2:30.
Please, my lord.
ಬಂದೆ ಎರಡು ನಿಮಿಷ ಸರ್ 64 ಏನಾಯ್ತು ಸರ್
230 ಅಲ್ಲ, serial number 70. ಅಷ್ಟೇ.
ಸರ್ 64
64, 2510.
26 sir. 26.
ಇದೆ ಇದು ಪಾಸ್ವರ್ಡ್ ಇದೆ.
ಅಪೆಲೆಂಟ್ ಟೈಮ್ ತಗೊಂಡ್ರಾ
ಹೌದು. 26, 2910. ಕಂಟಿನ್ಯೂ ಕರಿತಾ ಇರ್ಬೇಕು. ನೀವು ಯಾರಿಲ್ಲ ಅಂದ್ರೆ ಮುಗಿಸೋದ್ರಲ್ಲಿ ಕರೆಕ್ಷನ್ ಇರ್ತದೆ, ಚೇಂಬರ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಕರೆಕ್ಷನ್ಸ್ ಅದು ಮಾಡಿ.
And
What was, sir?
ಸರ್ ಹೇಳಿ
Sir?
ಹೇಳಿ ಇನ್ನು ಮೇಡಮ್ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ ಗೊತ್ತಾಯ್ತು. ಈಗ
Call
ಇದು
ಮಾಡಿ.
ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದಾವೆ?
ಒಂದು 5 ಇದೆ ಸರ್.
ಹೌದಾ? ಅಂದ್ರೆ ಎಲ್ಲ ಪಾಸ್ ಅವರಾ?
ಹಾ ಪಾಸ್
ನಂದು ಕೊನೆಯಲ್ಲಿದೆ.
ಲಾಸ್ಟ್ ಮ್ಯಾಟರ್ ನಿಮ್ದು.
ಹಾ ಹೌದು. ಸರಿ ಹಾಗಾದ್ರೆ.
ಬೇಗ Pass over matter, serial number 31. Prakasha HC.
In this
B.
case,
Pradeep.
I am for the appellant, B. Pradeep, our grandmother and a she is expired, kindly after 15 days. madam.
Sri Prakasha HC for appellant is present before this court. Its appellant counsel reports that Sri P. Pradeep, land counsel for R2 is unable to attend the court on this day due to personal inconvenience. Full stop. It is reported that there is bereavement at his family. Full stop. Therefore, stand over to 711.
Please.
Serial number 37.
Kindly refer the matter to Lok Adalat, madam.
Sri Prakasha HC for the appellant seeks to refer the matter to Lok Adalat for settlement. Since the matter is referred to Lok Adalat. for
Much obliged.
Serial number 40. Kavita HC.
Honor appeals.
Very difficult in the financial problem in the appellant. In the detail explain the memo of tax. Detail of the memo of tax, explain the detail.
You have to file in the filing
No,
section. What? You have not deposited the award amount.
No, no.
You have not paid the cost.
Just 1 week.
We cannot grant. So the appellant is not evincing interest in the appeal.
No, sir, no.
Then what is the fun in keeping the appeal alive? Sri Baira Reddy.
Baira Reddy.
Land Council representing Sri Kavita HC. Land Council on record for the appellant submits that the appellant is not evincing any interest in the appeal. Full stop. Land Council states that the appellant did not choose to deposit 40% of the award amount before the tribunal as ordered in IA-1 of 2021 dated 17/12/2021. Full stop. Land Council also states that costs were imposed by this court on 2/9/2024 and the appellant did not even pay the costs. Full stop. Having considered the submission thus made, this court is of the view that the appeal deserves dismissal. Full stop. Hence, the appeal is dismissed due to non-prosecution.
Serial number 43. Gopal Krishna N. Mohan Kumar T.
Morning, they asked for passover now. One is there.
We will admit and list for final hearing.
Started by given bit. One is death case, 2 ground surgery.
When the other side is not there.
Start date.
At request of Sri Gopal Krishna N. List on 19th September.
Please.
Next week.
Serial number 70. Girish B. Valdare, D. Vijay Kumar.
My lord, I am for the respondent, my lord. It can be disposed of a small enhancement.
Yes, Mr. Council.
Seeking for enhancement of the compensation, my lordship.
Yes.
Is aged about 52 years. The injury sustained by the claimant is fracture of left femur. The income taken by the tribunal is on lower side, my lordship. Instead of taking 15,000, 14,000.
Sir, occupation.
Yes, my lordship.
Coolie, my lord. Coolie
It was agriculture.
and mason and the rest.
An inpatient for a period of 6 days. Sustained
Fracture of left femur.
Yes, my lord.
Femur, my lord. Yes, my lord. My lord, if we take the notional income at 15,000 rupees, my lord, 15,000 into
Accident occurred in the year
2021.
2021.
2021. Yes.
Which are prospects have to be taken, my lord.
What is the disability, Mr. Council?
25% with respect to our left lower limb.
8% to the whole body.
Criminal taken 8%, my lord. Which
Kindly
is
see
in,
page 19, my lord.
Page 19 of the judgment, my lord.
Page 19 of the judgment.
Disability 8%.
8%, yes, my lord.
Yes.
The calculation is at page 21.
Income to later period is on lower side. Amenities is on lower side. And towards the food, diet, nourishment is on lower side. Towards pain and suffering, only the sum of rupees 25,000 is awarded. That required to be enhanced.
If we take 15,000 rupees, my lord,
Yes.
it will come to 1,54,400 as against 1,47,840. 10,560 will be the enhancement towards loss of future income.
No, my lord. 50.
The multiplier is 11.
11, my lord, into 8%. One lakh 54,400.
1,58,400.
58. 1,54,400. I don't know how I calculated. Please, my lord.
One lakh 58,400.
Please, my lord.
Inpatient for 6 days.
6 days, my lord. Income to later period has to be required to be enhanced, my lord.
Kindly take for 3 months, my lord.
Loss of income during later period.
3 months, my lord. You lost
3
me.
months.
Kindly take 2 months or 3 months. I leave to your lordship.
3 months will take you 45,000. Except loss of income during later period and the
Future loss of
future
income.
there is no need of interference in any other
The
aspects.
pain and suffering is on lower side, ma, only 25,000.
25,000.
And amenities also only 20,000 is awarded, my lord.
Yes.
And food and nourishment only 6,000 is awarded. That
Yes.
required to be some
That
marginal
will
enhancement.
enhance to 20,000. The total enhancement would be 55,560.
Loss of amenity is another 10,000 may be awarded.
Uh,
Loss of amenity is another 10,000.
no, Mr. Council, we have awarded 20,000 for diet, food nourishment and attendance charges.
That is only for 6 days though. It is only for 6 days.
Yes.
Anyway, either this way or that way.
Yes. Heard. Sri Girish P. Baldari, Land Council for the appellant, as well as Sri D. Vijay Kumar, Land Council for the respondent. While Sri Girish P. Baldari appears physically before this court, Sri D. Vijay Kumar appears through VC. Next, the claimant in MVC 1406 of 2021, which stood pending before the Additional Motor Accidents Claims Tribunal Hassan and was disposed of on 27/9/2023, is before this court through this appeal seeking enhancement of compensation. As against the claim for rupees 20 lakhs in total, the tribunal through the impugned order awarded a sum of rupees 3,11,605 as compensation. Explain. Arguing the matter, Sri Girish P. Baldari for appellant submits that the appellant, as an agriculturist, was earning rupees 20,000 per month by the date of accident. The appellant sustained grievous injury due to the accident and became permanently disabled. However, taking the notional income as rupees 14,000 per month, the tribunal awarded a meager sum under the head loss of future earnings, which is unjustifiable. Land Council also states that the amount awarded under all other heads is also grossly low. Land Council ultimately seeks for enhancement of compensation. Next, further submission is made by Sri Girish P. Baldari that the accident occurred in the year 2021 and for the relevant period, the Karnataka State Legal Services Authority is taking the notional income as rupees 15,000 per month, and at least the said figure should have been adopted by the tribunal. Without raising any objection with regard to the notional income to be taken at the rate of 15,000 per month, Sri D. Vijay Kumar states that the disability as assessed by the tribunal is 8% and the same needs no interference. This court is convinced with the submission thus made. The disability as assessed by the tribunal is proper. Also, the multiplier to be applied is 11 as observed by the tribunal. Though it is contended that the appellant as an agriculturist was earning rupees 20,000 per month, in the light of absence of any proof to that effect, this court considers desirable to take the notional income of the appellant as rupees 15,000 per month. Thus, the loss of future earnings due to permanent physical disability is as under: notional monthly income 15,000, annual income 1,80,000, apply appropriate multiplier 11, 19,80,000, 8% being permanent physical disability, loss of future earnings 1,58,400. The next one, the tribunal through the impugned order awarded a sum of rupees 1,47,840 only under the head loss of future earnings. Thus, the enhancement in this regard will be rupees 10,560 within brackets 1,58,400 minus 1,47,840. Next point. It is not in dispute that the appellant sustained fracture of left femur, which is grievous in nature. Full stop. It is also brought on record that the appellant was treated with it is also brought on record that the injury was treated with closed reduction and internal fixation with PF nail. Full stop. Further, it is also brought on record that the appellant took treatment as
5 days.
inpatient for 6 days. Full stop. Having considered the nature of injury sustained, this court is of the view that the appellant would not have attended her normal pursuits at least for a period of 3 weeks. Full stop. Thus, the loss of earnings during laid-up period comes to rupees 45,000 within brackets 15,000 into 3. Full stop. The tribunal, through the impugned order, awarded a sum of rupees 14,000 only under the head loss of income during laid-up period. Full stop. Thus, the enhancement will be 31,000 within brackets 45,000 minus 14,000. Full stop. Also, the amount awarded, that is rupees 6,000 under the head diet, food, nourishment, conveyance, attendant charges and other incidental expenses is grossly low. Full stop. This court is of the view that the appellant is entitled to a sum of rupees 20,000 under the said head. Full stop. Thus, the enhancement will be 14,000 within brackets 20,000 minus 6,000. Full stop. Next, therefore, in the light of the foregoing discussion, the appellant is entitled to a sum of rupees 55,560 within brackets 10,560 plus 31,000 plus 14,000 brackets close, in addition to the sum that is awarded by the tribunal as compensation. Full stop. Thus, the appeal is disposed of with the following word. The appeal is allowed in part. The compensation that is granted by the additional motor accidents claims tribunal Hassan through orders in MVC 1406 of 2021 dated 27/9/2023 is enhanced by rupees 55,560. Next, the enhanced sum shall carry interest at the rate of 6% per annum from the date of petition till the date of deposit. The second respondent is directed to the
Only one respondent.
Only one respondent, yes.
The respondent is directed to deposit the enhanced sum within a period of 8 weeks from the date of receipt of copy of this order. On such deposit, the appellant is permitted to withdraw the entire amount.
Much obliged. Much obliged.
Wakalat not filed. A week time is granted to Sri D. Vijay Kumar to file.
Please, my lord. File wakalat. Yes.
ಅದಕ್ಕೆ ನಾವು ಒಂದಿನ ಹಾಕ್ತೇವೆ ಒಂದಿನ 12 ಬರೋದು ನಾವು ಒಬ್ಬರು ಅಟ್ಲೀಸ್ಟ್ ಇವತ್ತು ಫ್ರೀ ಇರ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್